Good morning, everyone. We're going to get started. You can feel free during the conference at any time to get some more food or warm up your coffee. I'm Andrea Razzo, and I'm your host for today's conference, the title of which is way too long for me to read out at this point in time, but we do have a variety of topics that we wish to cover today. I do apologize for my voice. I assure you I am not contagious, but I will try to speak as little as possible during today's presentation. Before we begin, I would like to acknowledge that we are situated on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations. Today's presentation will feature your regular labor and employment lawyers, except for Catherine Reppel. Catherine caught whatever it was that I had, so she's unable to be here today. But in addition to our regular labor and employment lawyers, we have three very special guests to speak with us today. The first is Scott Lamb. Scott's practice includes privacy law, including investigations and complaints before the BC Privacy Commissioner, freedom of information requests, policies, contract, and compliance procedures. Scott has been named one of the best lawyers in Canada over the last few years. And up until last year, for 5 years in Scott's free time, he was the president of the Conservative Party of Canada. Scott will be speaking on privacy issues, and we look forward to hearing from him. After Scott speaks, we'll hear from John Soden. John Soden is an immigration lawyer in our office. He has, in addition to his law degree, he has an MBA and a management consultant designation. John helps businesses onboard and retain talent from abroad. His services include obtaining work permits, labor market impact assessments and exemptions, immigration audits and inspections, and other facets of immigration issues for our corporate clients. Pu Zhang, who is seated beside John, is an immigration consultant and paralegal in our office. She has 10 years of experience in the field and 5 years of legal experience in government positions. She assists our corporate clients in assisting talent coming from abroad with family sponsorships, entrepreneur programs, citizenship, and personal nominations, along with all other aspects of immigration assistance. Next to me, you probably know Debbie. Debbie practices in the areas of employment and labor. She also does insurance work. On the labor and employment front, she is involved in all areas of employment-related matters, including human rights, restrictive covenants litigation, drafting of contracts, and wrongful dismissal claims. For those of you who I have not yet met, I am the chair of the employment and labor practice at Clark Wilson. I have practiced exclusively in the area of employment and labor law since 1992. I service clients in all areas related to human resources, and I've appeared before the Employment Standards Tribunal, Employment Hearings Tribunal, Labor Relations Board, Workers' Compensation Review Board, WCAT, and I've appeared before all levels of court in both Ontario and British Columbia, as well as the Supreme Court of Canada. Without any further ado, I will now turn it over to Scott.
Well, thank you, Andrea, and thank you for the very kind introduction, and welcome, folks, to my portion of the seminar today. And what we're going to talk about is privacy law and what employers need to know. And the first thing to really note about privacy law is it's really a broad range of concepts, legislation, and case law. And it's rapidly evolving and growing. And what I usually have to do in these sorts of things is tell people what we're not going to talk about, because it's so broad-based and everybody has an idea what privacy law is. So the first thing we're not going to talk about is the Charter. Although there's an implied right to privacy in the Charter, we're not going to deal with that today. There's also, it's been recognized in Ontario, a common law right in terms of privacy, the tort of an invasion of privacy, and the tort of internet harassment. That hasn't been recognized under British Columbia law, but in BC we have our Privacy Act, which is a statutory tort of invasion of privacy. I'm not going to talk about CASL. You may have heard about CASL. That's the anti-spam legislation. I'm not going to talk about sectoral laws that have implications for privacy, such as the Bank Act or consumer protection laws. And I'm not going to talk about access to information laws. That's FOI requests, Freedom of Information requests that you make to the government and public bodies to find out information that they may hold. Nor am I going to talk about public sector privacy law. Your rights for privacy vis-a-vis governments and governmental bodies, whether provincial or federal. But what I am going to talk about today is the private sector privacy laws, and both federal and provincial. And this is really what governs most organizations, and this is where there's a lot of activity and a lot of changes, which I'll get into later. So the first thing I want to set the table a little bit is the federal privacy legislation. In Canada, we have two tiers of privacy legislation. The first tier is at the federal level with the Personal Information Protection and Electronic Documents Act. And we affectionately call that PIPEDA. And that governs federally regulated industries, railways, banks, telecoms, airlines, that sort of thing. It also governs where personal information moves across interprovincial borders. So if personal information moves from Alberta to British Columbia, the federal act will apply. It will also apply if you move personal information from British Columbia across an international border to Washington State. And it also applies in Canada where provinces have failed to pass legislation which is similar to PIPEDA. In our case, British Columbia has passed that legislation along with Alberta and Quebec, and Ontario is scheduled to do so as well. Should note here also that the healthcare sector is treated specifically in large parts of Canada with its own privacy legislation. So in BC, and this is what we're going to talk about a fair bit, and particularly with respect to employment law, we have the Personal Information Protection Act, and we affectionately call that PIPA. Lawyers just can't help themselves with all these little acronyms, but if you can keep track of them, PIPEDA federal, PIPA provincial. And that's, again, personal information within British Columbia. Now, there's 10 principles that I always like to remind people of that govern our privacy legislation. And this is originated from the EU, EU law, and it is really embedded in both the federal and the provincial acts. I'm not going to go through all of these principles. I'm going to only focus on a couple of concepts that are very, very key for privacy law and should be things that you should be aware of, particularly as they are going to be changing with some reforms that we see coming forward. The first concept is really, and I'm going to try this little number here, is consent. And that's really the heart of our legislation. So it's the knowledge and consent of the individual are required to collect, use, and disclose personal information. The next concept to that is number 5, limiting the use, disclosure, and retention of personal information. And that is really key. So if you can keep in mind consent and the purposes, number 2 as well, the purpose of which the information is collected have to be identified. So keep those concepts in mind, and that's going to guide you through a lot of privacy legislation. Okay, moving along. People often ask, well, what do you need to get for consent? That's a sliding scale. There are no bright lines in our legislation. It's a principle base. The more sensitive the information, the higher the obligations are in terms of consent, and then common sense prevails where you can get implied consent. I use the example. You go to the store, you buy a pack of gum, you give them your credit card. That credit card has a ton of personal information on it. You'd think, well, you got to have consent. No, it's implied. It just makes common sense. However, on the other end of the scale, if you have health information or you have financial information, and you're disclosing that to a financial institution, you're going to have express consent in writing and you're likely to have someone sign or initial that consent. So there's more obligations for formality of consent, the more sensitive the information. Now, of course, there are exceptions to consent, and a lot of these are, I'm not going to go through all of them, they're in the materials, but a lot of them really, frankly, make common sense, that you don't need consent if, for example, it's necessary for medical treatment and the individual is unable to give consent. Things like public source information, your business contact information, that's accepted. You've got authorized by law, you have facilitating a collection or payment of a debt, and that sort of thing. So those exceptions generally make sense, and they apply similarly in the federal and provincial legislation. Now, we're here at an employment context, and so it's important to talk about PIPA and the employment provisions. When this was passed, there were express provisions to govern employment situations. And the one thing that, just a little bit of a reminder, in this context, employees include volunteers. Just because you don't pay them doesn't mean that PIPA doesn't apply to them in the privacy context with the rules involving employees. So for employees, the Act covers the starting, managing, or ending of an employment relationship, and no consent is required to collect, use, or disclose employee information. But, and here's the but, you must give prior notice to an employee before doing so and explain the purposes of doing so. So no consent, but you have to give prior notice. Now, it begs the question, what's employee information? The statutory language is personal information about an individual that is collected, used, or disclosed solely for the purposes of reasonably required to establish, manage, or terminate an employment relationship. What does that mean? Employment resources activities, letters of applications, results of interviews, personal references, performance reviews, letters of resignation, termination documents, disability claims and benefits. So that allows you as human resource professionals to manage that relationship without getting consent all the time. Retention of employee information. This is really important. If an organization makes a decision using employee personal information that directly affects that employee, you must keep it for 1 year. You must. Otherwise, the organization must destroy the personal information once the purpose for which it was collected is no longer served by keeping it and is no longer required for legal or business purposes. So 1 year, or otherwise legal or business purposes. The next big topic, and I've actually spent a whole seminar dealing with this at times, and I can't give you all the gory details of this, but this is a topic that really people really want to talk about, employment monitoring, and in the employee context. And the types of monitoring you get are video monitoring of software, GPS tracking, and biometrics. Now, when you're dealing with video monitoring, when you have continuous video surveillance, it's only reasonable when it's used as a last resort, and the video camera really, in the end of the day, can't replace employee supervision. And what a bit of a theme you get is the more that you're monitoring tends to look at employee performance rather than purposes such as security or safety. Those are the two ends of the spectrum. Safety and security, likely the Privacy Commissioner is going to think it's reasonable. Employee monitoring, not so much. And so you have to be careful with that. Now, there's lots of monitoring software. You have keystroke logging, automated screenshots, and continuous tracking of computer activity. And that's really not going to be reasonable if it's beyond the protection of the IT systems and infrastructure. And excessive amounts of this type of monitoring of personal time of employees is going to get you into trouble. GPS tracking, remember this is not just vehicle location, but it also can give braking information, seatbelt indicators, it can driver behavior generally. And the thing to remember, it's not information about a vehicle, it's actually personal information. And that's a key concept to understand when you have GPS tracking. And if it's to ensure employee safety and track for billing purposes, that's likely to be reasonable. But if it's used outside work hours and continuous monitoring for alternative purposes, you're probably going to have some trouble there with the Privacy Commissioner. Biometrics, eye, face, voice, and fingerprint scans are becoming more prevalent. The big takeaway on that is, and the thing that surprises people, but a lot of research is showing that those have significant fail rates. It's not actually that accurate. One thing that the Privacy Commissioner will look at and analyze is one-to-one verification using those scans and biometrics is reasonable. And what I mean by one-to-one, you get a driver's license and then you verify it with a fingerprint to make a match. That will likely be reasonable. Where it won't be reasonable is one-to-many identification. So in other words, you have a fingerprint or a facial scan, and then you scan it against all records. So you have this big database of facial scans, and you try to verify it that way. There's recent case law dealing with exactly that situation and it was used by the RCMP, it was used by other private sector companies, and the provincial and the federal privacy commissioners went pretty hard on that and found it to be unreasonable. So one of the things to try to give you some guidance is a general test for employment monitoring. So start running these questions through your minds whenever you're looking at employee monitoring issues. Is the monitoring necessary for a legitimate or reasonable purpose managing the employment relationship? Past safety or security incidents? Is the information collected necessary to meet the legitimate purpose? Were less privacy invasive alternatives considered, and would they be effective? Were the employees given notice of the monitoring, and is there a policy governing the use, retention, and safeguarding of information collected? And if you have to do surreptitious monitoring because of the nature of your security or safety concerns, those first 3 points become a very high threshold, just becomes a higher threshold. So the next area that I think you all have to be aware of, and again, it can be a topic all unto itself, is breach notification for data breaches. And that's mandatory under the federal legislation of PIPEDA. It's recommended for PIPA because it will soon be mandatory. It's on the agenda of the Privacy Commissioner of BC, and the government reforms that are anticipated for PIPA will include this. And the reason why in your context it's important is because many people believe that data breaches are all about third-party hackers. Most of the data breaches actually are with your own employees, getting a hold of information and personal information that they should not get a hold of. And that's actually what a lot of data breaches are all about. So I really want you to pay attention to breach notification. Now, do you need to report all data breaches to the Privacy Commissioner and the individual involved? No. But you must report breaches to the individuals and the Privacy Commissioner if, and here's some magic words, it is reasonable to believe there will be a real risk of significant harm to the individual. And of course, that always begs the question, what does that mean? Significant harm means humiliation, damage to reputation or relationship, and identity theft. So loss of employment, loss of business or professional opportunities, negative effects on credit record, financial loss. And what does real risk mean? It means considering the sensitivity of the information and probability of misuse. And notification to the Privacy Commissioner and to individuals has to be given as soon as feasible so that the individual can understand the significance of the breach to them and take steps, if possible, to reduce the risk of harm. And on the federal level, the fine for this is $100,000. So it has a bite. I'm not going to talk about privacy management programs, but there's a lot of good information about that, and have a look at that. And I'm not going to talk also about privacy impact assessments, but those are things that you're going to have to be more and more conscious of and how you put those together. What I am going to talk about a little bit more is, and I think this is important for folks in this room, is what's coming. And there's reform of the federal law. Bill C-27 is in Parliament right now. It hasn't gone to second reading or to committee yet, but we expect that to happen this fall. And we think it's going to be implemented sometime in 2023. And it's the same frame, it represents actually an entirely new act. It's going to be called the Consumer Privacy Protection Act. And it's the same framework as PIPEDA, but it really modernizes Canadian privacy law to bring it up to the standards of the European Union, the GDPR, which is another acronym for you to remember, which is General Data Protection Regulation, and more recently, the California law, which is probably the most stringent privacy law in the United States, the CPA, the Consumer Protection Act. So a lot is going on with that. There's a reform in BC coming. A special committee of the BC legislature has recommended 34 changes. It will also follow what the changes are in the federal act. As I said at the beginning, you have to avoid in BC the federal act applying, you have to have similar legislation in BC. It can be slightly different, but it has to be similar. And things like data breach notification, which are not in BC law, will have to be implemented. So there's a bunch of stuff that needs to get done there. And we expect those draft legislation probably sometime in 2023. Enforcement under the new CPPA. This is the federal changes. The Privacy Commissioner has been given enhanced powers. The Privacy Commissioner conducts an inquiry after investigating a complaint, and then the Privacy Commissioner renders a decision, and if there's a contravention of the Act, they can issue a compliance order. But now they can recommend to a new tribunal to impose penalties. And hold your breath, here are the penalties. Tribunal has the power to impose penalties up to $10 million or 3% of gross revenue, whichever is higher. So that's big, and that's in line with the EU. The EU loves to pound American social media platforms with big fines, and I think our Privacy Commissioner wants to be able to do the same to Facebook and whoever else they don't like. And so that's going to be big change, and everybody should be conscious of that significant penalties that can be awarded. And they even go up a little bit higher to $25 million or 5% of gross revenue, whichever is higher, for particular contraventions. And look at the first one. Knowingly contravening breach reporting and notification. So you can see how important data breach notification is. Knowingly contravening the requirements to retain the personal information. Someone says, hey, what do you have? What personal information do you have on me? And then next thing you know, it's all deleted. Well, that's a really bad thing. It could put you into this place. Knowingly to use de-identified information to identify an individual, contravening the compliance orders of the Privacy Commissioner or obstructing their investigations. This is also a big one. In the new act, there is a right of private action where the Privacy Commissioner has found a contravention. So they may not recommend this to go to the tribunal, but once they've identified a contravention, you can go out there as an individual and sue them. And that's a blessing for the class action bar. They love this stuff. And class actions are already prevalent, of course, in the privacy area. Although it's interesting to see the judges across the country are performing a gatekeeping operation, it seems, on privacy class actions and trying to limit the effect of them. We'll see how this all translates, but effectively what we're seeing in the case law is the reluctance of the court to allow class actions to go forward, which are just merely a nuisance to people's lives in terms of the potential damages that they've actually suffered. But the class action bar is extremely aggressive, and so this is something else you have to worry about, not just the effects of what the privacy commissioner and their tribunal may award against you, but what that class action bar may come after you for. And the concept we talked about, and I emphasized at the beginning, was enhanced consent. And thank you. I talk forever, so Andrea has to give me little hints as to how much time I have. So enhanced consent, I do want to talk about this because it is the heart of the privacy law, and it's something we need to really be careful about, because the new act will up the game that you'll need to have for consent. The consent must be in plain language for the information to the individuals that they would reasonably be expected to understand. So it's the purposes of the collection, use, and disclosure of the information, but also the manner in which the personal information is to be collected or used or disclosed, and then the reasonably foreseeable consequences of that, and then the specific types of personal information that are involved, and then the names of any third parties or types of third parties to which personal information may be disclosed. So that is an enhanced consent obligation being posed going forward. Now, there's balancing that is some new provisions that exempt you from consent, and these are important to note. First one, and this is in line with what's happening in Europe. First one is a business activity consent. So organizations may collect or use personal information without consent or knowledge of the individual for specified business activities where the activity is necessary to provide a product or service, necessary for the organization's information systems or network security, and necessary for the safety of a product or service. And those are where you can fit within that. But of course, being lawyers, we always have to give you a but, and the but is organizations relying on this exception must only collect or use the personal information without consent or knowledge where, here's the language, a reasonable person would expect the collection for use of such an activity, and the collection or use is not for the purposes of influencing an individual's behavior or decisions. That last little bit, you may have caught the news about Cambridge Analytics, and particularly in the political world, where they were scraping Facebook and trying to supposedly influence voting behavior. Privacy commissioners in federal and provincial level are very concerned about this type of activity. So the business activity exemption, you will be offside if it's deemed to be for the purposes of influencing the individual's behavior or decisions. The second major exception to obtaining consent is where organizations, it's legitimate interest, and it's organizations may collect or use personal information without consent or knowledge if it is for the purposes of an activity in which the organization has a legitimate interest, which outweighs the potential adverse effect on the individual. And similar to what we just went through a moment ago, a reasonable person would expect the collection or use for such an activity, and the collection or use is not for the purpose of influencing the individual's behavior or decisions. Now, again, there's an added but. But prior to collecting or using personal information on the basis of a legitimate interest activity, the organization must identify potential adverse effect on the individual that is likely to result, identify and take reasonable measures to reduce the effects that will occur or to mitigate or eliminate them. This is effectively, you have to do a PIA, a personal information assessment, and that must be available to the privacy commissioner. So if you're relying on this exception and there becomes an issue about it, and the privacy commissioner knocks on your door, you're going to have to pull up this piece of paper, private information assessment, and say, hey, we did all the reasonable due diligence to ensure we could comply with this exception. There's no consent also required, no consent also needed for de-identified information, and that's a very interesting exception. And I'm not going to go through a lot of detail on that, but one thing to note about that, that's de-identified is different from anonymized. Anonymized information is completely outside of the act. It just doesn't apply. And so where does that occur? that anonymized information means to irreversibly and permanently modify personal information in accordance with generally accepted best practices to ensure that no individual can be identified from the information, whether directly or indirectly by any means. De-identify merely means to modify the personal information so that an individual cannot be directly affected from it, though a risk of an individual being identified remains. So that's significant. Right to disposal, I've got some information for you there on that. One thing to remember is the right to disposal under the new legislation will not be a right to de-index, or what is often referred to as a right to be forgotten. That's what you have in EU law, and the new Quebec legislation has been amended, does tend to give you a right to be forgotten. Outsourcing, they cleaned up this. There's been some controversy. When you have your data processed by a third party, what are your privacy obligations? It was generally understood, so long as it was on a similar terms as to what you collected, used, and disclosed the information, and they only use it for that purpose, that data processor, that third-party provider, then you're okay. The legislation makes it very clear what they're looking at now and what they want. An organization to transfer personal information to a service provider, your data processor, without consent or knowledge. You don't have to give the individual consent or knowledge when you do that, but you must require that the service provider provide a level of protection equivalent to that to which the organization is required to provide the individual the CPPA, under the CPPA. So whatever obligations you have under the Act, you impose those contractually onto your service provider. So you have to review those contracts and make sure that they're compliant. There's some new changes for minors, and looking at that, and also automated decision systems. And finally, there's going to be a whole new act, which is going to be introduced at the same time, on Artificial Intelligence and Data Act. And that's very significant. Artificial intelligence is affecting all our personal information, and the government is very, very sensitive to this, and is in fact, as I said, introducing a whole new piece of legislation to deal with it, and the ramifications of that will be seen in the future. But that's a lot. You took a lot by a fire hose, and hopefully you've got some good questions for me later on. But I'll turn it back over to Andrea.
Hi, I'm Andrea, apparently. Thanks, Scott. So, this is going to be interesting because I'm going to need to read on this with my glasses and read that. So I'll be doing quite a bit of that. I do apologize. Because I'm short. I'm not as tall as I would like to think I am. Hi, good morning. John Soden. Thank you very much, everybody, for coming. And thank you, Andrea, for the introduction, which I just want to amend slightly to make sure I'm not, I didn't mislead Andrea unintentionally, and I don't mislead any of you intentionally. Andrea mentioned in the intro that I practice in various areas of immigration and labour market impact assessments. Now, I am going to mention labour market impact assessments throughout the next few minutes, but I'm actually going to mention them in the negative. So wherever possible, we try never to do labour market impact assessments. Okay? And that's one of the things that I'm going to reinforce here this morning with you, that there are many, many ways of getting people, foreign workers, to come and work in Canada and to get work permits without needing to go anywhere near a labour market impact assessment. So, Andrea, my apologies. So what we've put together here has just come out of questions that we've had from previous presentations, and also from our direct experience when we're working with our clients. Whenever, whether our existing clients or their new clients, they always come to us with the same question: is, I need to get this person or these people to Canada, and I need them to be here as quickly as possible, and I need it to be as certain as possible, and for the best value for money. You know, what's it going to cost? So I'm going to discuss, give you an overview here in the next few minutes of 5 programs, 5 immigration programs that we use. 98, 99% of the time, and that when we use them, I would say are almost 100% of the time successful. And I'm going to say it again, they don't involve a labour market impact assessment. Okay? So, let me start. Oh, I need to move on. So when we're talking to our clients, existing clients, well, we don't have to have that conversation with existing clients, but new clients, we always have a conversation and we always arrive at the same position, which is, well, what do they want and what do the foreign workers that they want to employ want? And they're the same thing, essentially. They want the highest chance of success. They want the best chance of success to get this work permit so that these people can come to Canada to work and they can come as quickly as possible. So that's minimum delay. Every day that you don't have a position filled is a week. Every week that you don't have a position filled is a month. Every month is a year in terms of productivity. If you didn't need that position filled, then why are you looking for employees? But you need to think about that internally. If you don't have a position filled, what is the opportunity cost that's racking up there? This is what employers and employees want, and it's always the same, and which is a good thing because that makes everything consistent. So how do we achieve those? Well, when we're talking to employers, and we're always talking to employers first. We're not talking to the employee first. It's always you that come to us. You contact us, you tell us what your need is, you tell us who you've identified or what you've identified. So how do we do that? Well, everything works on information and documents. We can't research things, we can't analyze things without a whole host of information and a host of documents for that. So we're always looking for detailed information about the employer, that's you. So if you're not an existing client, we'll want to know, well, what sort of business are you? Are you incorporated? Are you a partnership? Where are you incorporated? Is it in BC? Is it in another province? Is it extra-provincially? Or are you a federally incorporated company? Where are you based? Do you have business licenses? And we'll also want to know, what sector are you in? What size of company are you? Then for the employee, well, we need personal information about the employee, which may or may not touch upon what Scott was talking about with privacy. But there, what do we need? Well, certainly we need a passport first. We need to know who this person is and where they come from. And a crucial thing, and you would be surprised how often this happens, is an employer will say, well, we have this person and we want them to come and, we've interviewed them and they're the right person for us. And we take a look and then we find out, often with Americans and US citizens, that their passport's expired. So we're a non-starter at this point in time. So the first thing is get this person to renew their passport immediately. We also need a resume. We need educational certificates as well. So we need to know all of this background, personal and professional information. And the personal information, there's a lot of other things that are needed about admissibility to Canada. So we provide a questionnaire that we ask the employee to complete. So we want to know, have you ever been arrested? Have you ever been convicted? Have you ever been denied a visa? All of those sorts of things. Because those can be showstoppers further down the road, and you really need to know if there's going to be a showstopper at the beginning. Otherwise, you're just doing a bunch of work that may not come to fruition. So in terms of minimum delay, so I don't know if you're aware, but there are essentially two ways that somebody can obtain a work permit, how they can apply for a work permit. One is you make an application at a visa office outside of Canada. Let's say you're French, so you make an application to the visa office in Paris. The other is for certain people from certain countries is that they can present themselves at the port of entry, a port of entry being an airport or a land border, and they can make the application at the port of entry. Now, if you make an application in a visa office, you're going to be subject to the processing times in that visa office, which can be lengthy. COVID-19 certainly increased them, and some visa offices are 6 and some are 9 months. That's not good if you want an employee to start with you pretty soon. So if you have people that you've identified that you want to employ, foreign nationals, and they're eligible to apply at the port of entry, we always bring them to the port of entry with an application package and make the application at the port of entry. So, you know, people say, well, how soon can I get this work permit? The answer to that in that context is as soon as we have all of the information and documents to put the application package together, the only thing it depends upon is the ability of your chosen employee to travel. Yeah. So it may take, let's say, 3 or 5 months in the visa office, or it may take us 2 weeks to get it together for a port of entry. 2 weeks, 5 months, it kind of makes its own argument, right? For those that do have to apply in a visa office, if we can, we will ask for what's called a 2-week processing. Now, this is very, very variable. The immigration authorities are supposed to do this for certain categories, certain occupations, but it's very variable as to whether they will actually do it. And I would say, probably due to COVID-19, we haven't had anything that actually got approved within 2 weeks. It's always taken longer, and we've always had to make multiple inquiries and to get them through. So we get to the best value for money by 1 + 2 equaling 3. So golden rules. I'm going to mention LMIAs again. Now, all golden rules are equal, but some golden rules are more equal than others. And the most equal golden rule is avoid the temporary foreign worker program at all costs, because the temporary foreign worker program involves an LMIA. Yeah. And an LMIA involves an awful lot of bureaucratic work, a lot of advertising and recruitment, and writing up reports and transition plans, and then being interviewed by Employment and Social Development Canada, and then getting maybe a positive decision or maybe a negative decision. So we're talking about weeks and months just to get through that process. So avoid that. As I've said, always provide relevant documentary evidence. So in terms of when we're particularly, any application, but if you've got somebody coming to the port of entry, you don't want them to be in a difficult position where an immigration officer says, well, I don't think you qualify for this program. So we always, I would say to an extent, and make no apologies for saying we over-engineer these applications to make sure that it's got all of the bases covered, every base covered. And we present it in a way that's very, very simple. So one flows from the other. So the immigration officer can find everything that they want very, very quickly. So we make it easy for them to understand and easy to make the decision that we want them to make. So our top 5. This is what we use 98% of the time. It's not going to work for all of you in every context. You know, this is specific to our, or drawn from our experience with our client base. So there's a program called Mobility Francophone. You may or may not know about that because it may or may not be relevant to you. This for us is the go-to. One of the reasons is because we have a number of French-based clients, right? So they have a lot of French employees who just so happen to speak French, which is pretty good. And this program allows them to come to Canada to get work permits in skilled occupations. So I've made a reference there to NOC OA and B, NOC being National Occupational Classification. And they can come to Canada and they can get a work permit provided they're being offered a job by a Canadian employer, and provided their habitual language of use is French. So when I say habitual language of use, so with their family and socially, but that doesn't mean that within the job in Canada that they have to speak French. and oftentimes they won't. They'll be speaking English, particularly if they're here out west. This program is applicable in all provinces and territories other than Quebec. Okay. And the reason for that is the reason for the program, the rationale for the program, is to try and get more francophone speakers throughout Western Canada and outside of Quebec. And obviously there's enough French speakers in the province of Quebec. Intra-company transferees is the second one. And again, it works for us because that's our kind of client base. So let me flip over. There's a little bit more, this has a few more eligibility criteria than Mobility Francophone. Mobility Francophone is the most straightforward. You know, do they speak French? Is it a skilled job? Is it outside Quebec? You know, if you can hit those three, then you're good to go. With this, there has to be clearly defined intra-company relationships between what's known as the sending company, that's the foreign company, and the receiving company, that's the Canadian company. Yes, so there has to be an intra-company relationship, so that they could be associated or it could be a wholly owned subsidiary. And then there has to be a relationship, an existing relationship between the employee that's being sent, and they have to have been employed by that sending company, the foreign company, for a minimum of 1 year in the last 3 years. And then there are senior management, functional management, and specialized knowledge categories, which require various different levels of evidence. Again, it's available, though, in all provinces and territories, including Quebec. So if you've got anybody who needs to work in Quebec, they can still use this program. Whereas they can't with Mobility Francophone, and they can't under the Temporary Foreign Worker Program. Quebec has its own version of that. Next, free trade agreements. Again, you'll see this on top of every slide, no LMIA required, and I really want to get that through to people. The labour market impact assessment process, it is, by the immigration authorities themselves, it is characterized as a program of last resort. And I strongly urge you to understand it as that. So free trade agreements, these are clearly defined, and there are many different ones. I mean, the most obvious or most well-known one is what's known as CUSMA these days, Canada, US, Mexico Free Trade Agreement. It's the successor of NAFTA. For immigration purposes, nothing has changed within that, from its NAFTA version to its CUSMA version. So there's a list of professions that within that can come to Canada and get work permits without any more ado than that, as long as they have a job offer from a Canadian employer. It's available to be used in all provinces, including Quebec. Significant social, cultural, and economic benefit. That's, it's pretty wide. What's significant? Now, this tends to be our fallback program. So if we can't fit anybody into one of the other programs, this is one that we will look at. And essentially, what we would have to do here is we have to demonstrate that the occupation that this person is going to work in and this person working in it, so this person's personal and professional and history, background, will create either I've got to get it right again, significant social, cultural, and economic benefit, or all three. Now, all three is a really difficult one to find. We have done it with clients where we've been able to demonstrate social and economic benefits, and we have been able to do it when we've just done it on cultural ones, but most of the time it's economic. It's very discretionary, so when I say discretionary, it's at the discretion of an immigration officer, but I would say to you that we've had a lot of success with this, and some of the examples there are artificial intelligence scientists, engineers, and senior managers in CCCs, community contribution companies. And if you don't know what those are, you know, they take less profit and they channel more of their reserves back into the company. And then something called International Experience Canada, which is also known as a working holiday program. This is for young people up to 35. So you can still be a young person at 35, apparently. Yeah, that includes you, Scott. There are differences over different countries. So some countries, their people are only defined as being young up to the age of 30. And others are defined as being young up to the age of 35. It just depends on what Canada has negotiated with those companies. Again, there's no LMIA required. We've used this when somebody, a company has got somebody, you know, they're going to be a little bit younger, they maybe don't have the educational credentials that are required in some of those other programs, they don't have the work experience. But we've used this with a number of clients, and we've used them, and it's been successful. So it's another option, it's another way of doing things. And I just want to, before I move on to the next piece, just want to give you an example. So, you know, what I was talking about at the beginning about, you know, we need information and so that we can tell you how to do these things. So this morning we're going to the office, we have an email from a client, and they have somebody that they want to bring to Canada. And they send us a passport and they send us a resume. So we don't get all of the information at that point. You know, we don't have a job description, but we know the company. So we have a look at this. So immediately we can start to sort of say, oh yeah, maybe that will go in there, maybe that will go in there. And the first things that appear is, okay, this person is not an intercompany transferee. However, this person is Portuguese and they speak fluent French, and they gained their degree in engineering at a French university. Okay, so this person, habitual French speaker, potentially. And then we look as well and we find, oh, look out, there we go, passport, that expires in early 2023. So back to the beginning, there's a few remedial things that need to be done here at the outset. But immediately we can start to see a pathway through one of these five programs. So I just want to make you aware of some regulatory changes that have taken place recently relating to foreign workers. Employers of foreign workers, not foreign workers themselves as such. So when you employ foreign workers, you make commitments to do certain things for them. You know, you're going to pay them like you said you would pay them. You're going to give them the holidays. You're going to give them the benefits that you said you were going to give them. Well, there's an audit and inspection regime that Immigration, Refugees and Citizenship Canada employs, and you could be subject to an audit for two reasons. The most obvious reason, or most common reason, is it's just a random audit that pops up and you get audited. Or an employee reports you. Either way, you're going to get audited and you're going to be asked to provide information and documents to support everything that you said that you would do for that employee. So now, because there have been reports of some, I guess, some variable practice, you have to, by legislation, you have to make information available to the employee about their rights in Canada. It has to be readily available. So you either give them something on a document, you know, these are your rights in Canada, this is what you can do, or more often, more obviously, it'll probably be on your intranet or something like that. But you have to do that. You have to have a signed employment agreement. It has to be in English or French. The workplace has to be free of abuse and or reprisal. So you're not abusing your employees. Nobody else in your employ is abusing your employees, these employees. And if they report it, there are no reprisals. They don't suffer any disbenefit because of that. And no fees to be charged to employees for recruitment. Well, that's always been the case, but they're just reiterating that because it still goes on. And you have to make reasonable efforts to provide employees with access to health services if they get injured or they fall ill in the workplace. So you have to be able to help them get to a hospital or help them get a doctor, things like that. And if you don't do those things, or you can't prove that you've done those things, there are a range of administrative and financial penalties. So at the low end, you might just get a slap on the wrist and say, make sure that you look after these things in future. But if it looks like there's something deliberate has gone on, then you're going to go up this scale. You could get fined, you could be banned from employing and using any foreign worker program for a period of time, and your company's name could appear on a blacklist. So something to be aware of. I hope I'm within my time, and I'm just going to ask Pooh, who's just going to come up and give us an update on a public policy, and then she's going to speak about an issue relating to expired and expiring work permits that we get lots of questions from employers about. Thank you.
Hi everybody, I'm Pooh John. It's my honor to present here today. Thanks to John for covering up all the 5 primary programs that we have been using to get work permit. So I'm going to briefly touch 2 more topics that I think can be very useful sometime, or most of the time I should say that. The first one is public policies announced by IRCC, Immigration, Refugee, Citizenship Canada. The 5 programs John just talked through are the long-standing programs which are stable and rarely changed. While public policies are usually implemented for a shorter period and can be revoked any time. What a public policy covers vary, but it's usually very specific. For instance, there is one specifically allowing foreign workers who are changing jobs to work for new employers while their application are in progress with RRCC. This can be very useful for employers, particularly now the processing time is almost 6 months long. There's another public policy RRCC recently announced. From November 15th next month to December 31st next year, international students are no longer subject to the limit of 20 hours per week working limit. So this will be definitely good news for our employers who have hired international students and wish them to work longer hours to solve some immediate labor shortage problems. Just to be sensitive that as they are still students, they must have the capacity to take on more job, and by the end of the day, they need to be able to fulfill their schoolwork. Public policies announced from time to time, they address current issues and often provided very needed help. And that was the first one. The second topic is a maintained status. We receive many inquiries regarding expiring work permits. Both employers and employees are panicking because it's clearly set on the permits that the foreign workers must leave Canada by such day. Well, without overcomplicating it, I would like to say most of the time, those foreign workers can continue working just as before and maintain the status, provided one, their renewal application is submitted before their original work permit expire, and B, they continue stay in Canada without leaving. I bring it up today because we are about a couple months away from Christmas. If you have, you might have employees affected by the prolonged processing time, and if they have planned to return to their home country, have holiday with their families, and they might not be able to work when they returned if their application is still not processed by that time. So having said that, it would be a good idea to check on them, just to give them a heads up, get to know about their travel plan. And there may be some more complicated case, and I would suggest you to discuss with us about the options. Okay, those are the public policies and maintained status I'm sharing today, and thank you for listening.
Thank you, Scott, John, and Pooh. That was terrific. We're going to take a 5-minute break. We will limit it to 5 minutes because we do want to have ample time for questions and answers at the end of our session. So we'll see you in 5 minutes. Thank you. So our next topic is remote work. And we know that this is a big topic out there, and you've probably received a lot of information. We are going to focus on the legalities of remote work. The first topic is which laws govern. I apologize, this is going to be fairly dry, but I think it is very important information for you to know. So let's deal first with employment standards legislation. As you know, employment standards legislation is provincially based, unless you are a federally regulated employer who falls under the Canada Labour Code. But I do believe that the majority of our attendees today are provincially regulated. Provincial legislation obviously varies across the country. Each province has their own employment standards legislation. As you also know, employment standards governs things such as hours of work, overtime, vacation, leaves of absence, holidays, how to pay wages, and of course, termination from employment. They provide the minimum standards that all employees are entitled to. Generally speaking, and if you get anything out of the presentation today, it's this, that generally provincial employment standards legislation applies to the province in which the work is actually being performed. For example, if you are a BC company, you only service BC, but you have an employee who works out of their house in Alberta. Generally speaking, that employee will be subject to the laws of Alberta with respects to employment standards. So that's the most important thing to remember, and a lot of employers just apply generally the law of the province in which they work, and that can get you into trouble. Teleworking, otherwise known as remote work, may blur the lines of where the work is being performed. Unfortunately, most of the legislation across the provinces provide very little assistance in determining when the legislation applies, if the general rule shouldn't apply. We have 2 provinces that do, New Brunswick and Ontario. Both say that the Act applies if all or part of the work is being done inside or outside of the province. And I'll get back to the interpretation of the legislation shortly. The rest of the province's legislation, including BC, is completely silenced with respect to the applicability. So generally, you will fall back to the rule of where the employee is actually sitting. That's where the work, that's where the province in which legislation will apply. So I'll give you an example of a case. This case actually arose in 2019, so actually before remote work started to be a very popular way of working. Mr. Zhang was a software developer, no relation to Pooh, was a software developer working out of IBM's Toronto office. He requested to work from home, and that request was granted. He and IBM smartly entered into an agreement that said the arrangement could be terminated at IBM's discretion, and that he would then return to a traditional work environment. So traditional work environment turned out to be a little bit of probably not the best choice of language, because it didn't really specify where that traditional work environment could be. So after a few years, Mr. Zhang decided to move to BC, as many Ontarians do, and he worked there for approximately 2 years until IBM said come back to Ontario. They wanted him to return to the Ottawa office, however, as opposed to the Toronto office, and they gave him an ultimatum, which he refused, and they deemed him to have resigned. He filed a complaint with employment standards that went to the Labour Board for review. And the Labour Board, it's not going backwards, was asked to interpret this language. Act applies to the employees working within Ontario and outside Ontario to the extent that the work outside Ontario is a contract of work performed in Ontario. what the Labor Board held was that for that language to apply, there must be some back and forth between Ontario and the other province, not a full move from one province to the other with only a possibility of some return. So the way it was interpreted is if an employee is generally working pretty permanently in a different province, the legislation of that province will apply. And we'll likely see a similar result if this were to be decided in British Columbia. And so why is this important? The reason why Mr. Zhang brought the case in the first place, he wanted Ontario law to apply because, as you know, Ontario, or you may not know, but Ontario has severance in addition to notice. So in BC, under the Employment Standards Act, if the employee is limited to that by way of contract, it's 1 to 8 weeks, depending on years of service. In Ontario, it's also 1 to 8 weeks, depending on years of service. But the employee, after 5 years of employment, is also entitled to an additional 1 week per year of service to a maximum of 26 weeks. So much more money could be had under the Ontario legislation. And so that's why the claim was brought. So it is very important that you get the legislation correct and that the parties know which legislation will apply. So one thing IBM should have done in this case is made clear that while you are working, at the time they did not know that he was going to move to BC, but at the time he did, there should have been said something confirming that he would be subject to the laws of British Columbia. They would have avoided the litigation had that been the case. So other considerations with remote work outside of employment standards legislation, consider international work. So I've just talked about the differences in legislation among the provinces. As you can imagine, if somebody decides to move to a different country, I often threaten that I'm going to start the Clark Wilson Hawaii office. That may bring up a host of whole other issues. And one example of that was just a couple of weeks ago. I don't know if you've heard this in the news, but an employee for an American company was working out of the Netherlands. That's where his family was, so he decided to work from there for a US company. The US company decided to do some productivity tracking, which Scott spoke about, which is okay in the US, but it is not okay in the Netherlands. The employee brought a claim to the Netherlands court and was successful and was awarded approximately $150,000 for that privacy breach. So again, beware if your employees are in a different country, you should make sure that you know the employment laws of that country. Other considerations are tax issues and also corporate issues. So will you be deemed to be doing business in another country or in another jurisdiction? What happens with taxes, corporate taxes and payroll taxes? Another consideration is human rights. So even across the provinces, they each have their own human rights legislation. We know that there are differences in the protected grounds. For example, BC is the only province that has a protected ground of political belief. I think there's one other province that might have that, but that's not a protected ground in other provinces, and other provinces may have different ones than in British Columbia. So know if your employee is working in Nova Scotia, they're going to be subject to human rights legislation, and you ought to know what that legislation says. And privacy laws. So again, I won't go into detail because Scott did an excellent presentation on privacy laws, but as you know, 3 provinces have their own privacy legislation, the rest fall under PIPEDA, and so you might have obligations in other provinces that you may not be aware of. So what should you take from all of this? So as I've already mentioned, consider the laws in your contract, put your mind to which law will apply. Be mindful that if you pick a legislation that the courts or the tribunals can often say, well, you're wrong on that. So you should not just pick it randomly. You should actually get some legal advice on who you think is going to take jurisdiction and make that clear in the contract so the employee understands going into the situation and you understand going into the situation. And again, as I've mentioned, know the employment standards differences, particularly in the jurisdiction where the employee is working remotely, as there are key differences. And another example besides the Ontario severance example, many of you may not know that in Nova Scotia, an employee cannot be terminated other than for just cause after 10 years of employment. So it's almost like a unionized setting that you just can't terminate due to redundancy, or you just want to go in a different direction. That employee is basically guaranteed employment. So really important things to know across the provinces. I'm now going to be Catherine Ruppel, and I'm going to cover Catherine's presentation, leaving aside which law applies. Now, what are some of the other considerations you should consider, with respect to the actual work that the employee is doing? So going back to the IBM case, it's very important to have a contract in place that spells out very specifically what the remote work arrangement is. So some of the considerations you'll want to include is whether or not the remote work is temporary. So is this supposed to be a temporary arrangement? Is it for a fixed term, or is it supposed to be a permanent arrangement for the life of the employment relationship? Is the remote work agreed upon? So who is initiating the remote work? Is it you, the employer, that really wants this employee who is sitting in England and really wants them? Or is it the employee who is coming forward? Make sure that it is agreed upon and all the terms are agreed upon, and that's one of the good things about having a contract. Like IBM, do you want to have the ability to retain, do you want to have the ability to have the employee return to the office at some point? Really spell that out very clearly, the mechanisms of how that's going to work. For existing employees who now say they want to go remotely, make sure you look to see what their employment contract currently says, especially if you are the one that is initiating the remote work. You want to be careful not to trigger a constructive dismissal. And for any agreements that you enter into, make sure that it is consistent, or if not consistent with the current employment agreement in certain respects, that you make it clear that the new agreement overrides the old agreement. Health and safety and workers' compensation is another key consideration. And our Workers' Compensation Board and RWCAT have made it clear that when an employee is working from home, they are considered to be at work, and therefore any injury that they sustain is compensable. And this makes it difficult for employers because you're not in their workspace. You don't see what their work arrangement is like. You don't see that they have a proper ergonomic chair. So this is something you're going to want to create by policy, a policy that puts the onus on the employee, even if it, at the end of the day, doesn't avoid a compensable claim. At least it puts the employee's mindset that they do have an obligation to create a safe workplace. I gave an example there of a case from WCAT this year where an employee was working from home. They were on the telephone and dropped a pen, and they bent down to pick up the pen and they herniated a disc. And that was deemed to be a compensable injury because the employee was in the process of work, even though the employer had no control over the workspace, where the desk was situated, and all of that. Now, there's been another case where an employee was working from home, got up and went downstairs to get some lunch in their kitchen and fell down the stairs. The WCAT said that was not compensable because it was during an unpaid lunch break. But had that been a paid lunch break, the employer may very well have been on the hook for any increased premiums that resulted. One of the ways to avoid this is to make sure that there are routine check-ins, especially if an employee is isolated, to make sure that the employee is okay. So accommodation issues will still continue to apply to employees who are working remotely. The big one that we're seeing today is childcare and family responsibilities. So during COVID, employers gave a lot of flexibility to employees who had childcare responsibilities, largely because daycares were closed and schools were closed. Some employees think that that continues to extend now, and some employers have given sort of an indication that it does. Make sure that if you are accommodating for childcare and family responsibilities, that it truly is a need that has to be accommodated, that it meets the legal test. That's another subject for another day. But just because somebody says they have to pick up their child at 3 o'clock in the afternoon and therefore have to work remotely, that does not mean that that's something you have to accommodate. That will not likely fall under the family status grounds. The other issue is disability that we see a lot of. Employees, whether or not it's some anxiety or mental issue that makes it fearful for them to come into the workplace still. Again, you may have to accommodate those issues, but again, make sure that there truly is a disability there and be proactive, especially if you're really working to get your workforce back into the workplace, at least on some sort of part-time, regular, consistent basis. So privacy, security, and confidentiality. So this is another issue that you're going to want to address by way of policy for remote workers. Remote work means working from a secure system in your home. It doesn't mean going down the street to Starbucks and going onto their Wi-Fi where all of the information in your system is now vulnerable to hacking. So, be very clear with your employees that when they are working remotely, they must take all reasonable steps to make sure that they're working securely. Scott already mentioned monitoring of employees. I won't repeat that, but good luck if you're deciding you're going to monitor your employees. So another issue is working hours and availability. You really should have a policy on this. You do not want employees regularly working overtime. It is the employer's obligation to ensure that employees don't work overtime. If an employee does, even without permission, you will have to pay for that because it's work provided to you. The best way to avoid this is to have the employee fill out a timesheet every day. And at the end of the week, send it into the manager so that, a year later, if they get terminated, they don't come back and say, oh, by the way, you owe me $40,000 in overtime, which we see in almost every situation when an employee gets terminated. All of a sudden, there's all this overtime that they worked. It is incumbent on the employer to prove they didn't work. It's not incumbent on the employee to prove that they did work it. So if the employer has no evidence to rely on, unfortunately, you're going to have to pay that money. So really be vigilant around hours of work. Finally, office expenses. And this includes computer, your PC, your laptop, your printer. The Employment Standards Act of British Columbia says an employer must not require an employee to pay any part of the employer's business costs, except as permitted by the regulations. I can tell you the regulations aren't helpful. So if the employee is working from home and working and providing services to the employer on a computer, that computer should be provided by the employer or paid for, reimbursed by the employer. So don't get caught up on that. It is a real, I know across a large number of employees it can become expensive, but failing to do that could result in a group employment standards complaint, and you would want to avoid that. So to wrap it up, policies are important. Oh, that's a cute dog. That's a cute dog. So yeah, policies are very important. If you don't have them in place, you're going to want to put them in now. We are happy to help. We can help draft your policies, or we can review them to make sure that they meet all legal requirements, and health and safety, accommodation, privacy, work hours, and expenses. With that, I will turn it over to Debbie to deal with terminations. When Debbie is done, we will open it up to question and answers. There is a mic in the middle of the room if you want to come up and ask a question.
All right. I appreciate you guys have had a lot of information thrown at you this morning. I will endeavor to be as entertaining as possible with the ever popular topic of terminations. So I'm going to start with a very brief overview, but I'm actually going to drill down into releases today and the use of releases when we're talking about terminations without cause. So as you're aware, probably there's typically terminations are going to fall into one of two categories. So there's a termination with cause, where the employer has no liability when it comes to providing notice or pay in lieu of notice. And then there's the without cause termination, where the employer has liabilities with regards to notice or pay in lieu. And so here, important to note that employees with terminated without cause are entitled to, at a very minimum, what's set out in the ESA. Absent any valid written employment contract, they will also be entitled to what we refer to as common law notice. Just a brief note on terminations with cause, again, not the topic of this presentation today, but just important to note that when you're approaching a termination with cause, just a reminder that cause, the threshold for cause in Canada is very high, so you want to be sure that you've kind of addressed all the circumstances surrounding that termination to ensure that you do have cause if you're proceeding in that manner. So as I mentioned, absent any valid employment contract, employees might be entitled to common law notice, and that's going to be greater than your ESA minimums, and it's going to be based on a number of factors, including the character of employment, the length of service, the age of the employee, and the availability of similar employment in that area. Okay, so drilling down further into terminations without cause. So when we're approaching termination with an employee, there are a few preliminary matters that are going to be beneficial to consider. So most importantly, as I've already mentioned, does this employee have a written contract? And not only that, but does the employee have a valid written contract? Because again, this is really going to affect the employer's liability when it comes to that notice or pay in lieu of notice. And again, this isn't the focus of the presentation, so I'm not going to go into too much detail, but when we're thinking about the employment contract, it's important to consider things like, was the contract signed prior to the employee commencing work? When we look at those termination provisions, are those termination provisions enforceable? Are they up to date with the most recent language we're seeing from the courts? Another issue to consider is the circumstances surrounding the termination itself, and you want to turn your mind here to whether or not there might be any potential claims from this employee. So is this an employee who might file something like a human rights complaint or a claim for wrongful dismissal? As I'm sure you're aware, these liabilities can be quite costly and time-consuming for employers. And so ideally you want to be as proactive as you can in eliminating any of these potential liabilities, not just before termination, but during the termination process itself, as well as after the termination. So on that note, one of the ways you can do that is through the use of a release. So when we help clients navigate terminations without cause, any of you that have done that process with us will know that it typically involves two letters. So the first letter that we will help you draft out is what we refer to as the termination letter. So this letter is to do with the termination itself. It's going to include the date that the termination is effective. It'll probably set out the notice period or the pay in lieu of notice. It might also include other things like when the health and dental benefits are going to cease, might request the returning of all company property, might include a provision regarding the employee's ongoing obligation with respect to not using, keeping, or disclosing any confidential or proprietary information. So that first letter is to do with the termination. The second letter is the release letter, and this letter sets out a without prejudice offer in exchange for signing a release. Now, you'll see this is going to come up numerous times, so it's very important. The key consideration here is that an employer cannot get a valid release from an employee without, in exchange for providing valid, what we call consideration or payment. So employers, unfortunately, you can't get a release in exchange for providing any employee entitlement. So pay in lieu of notice is something an employee is already entitled to, so that won't be considered sufficient consideration in exchange for a release. The pay in lieu of notice becomes part of the termination letter. A gratuitous payment is provided with the release. There we go. So again, you must provide that gratuitous payment in exchange for signing the release, otherwise the release won't be enforceable and valid. And we appreciate that employers, when they're approaching terminations, it can be difficult to kind of wrap your mind around and not get frustrated by the financial impact that terminations can have. Because you're obviously approaching this, you already owe them notice or pay in lieu of notice, possibly already owe them common law notice. And so it can be a frustrating conversation to try and understand why you would be providing them anything in addition. But the gratuitous payment is required when you're entering into a release document. So sometimes employers will try to be creative to navigate these financial liabilities, and they might, like I said, want to provide the pay in lieu of notice, which wouldn't be valid. They might also want to provide a bonus to that employee in exchange for the release. And this can be a bit of a gray area, because if that bonus is something that that employee is already going to be entitled to based on their employment contract, then again, that's going to fall in the basket of an employee entitlement, and it's not going to be sufficient for signing the release. So again, just keeping in mind, what is the gratuitous payment you are providing in exchange for this release, and is it truly gratuitous, or are you kind of putting yourself in a position for an employee to come back and argue that that was an entitlement that they were provided? And I'm sure you'd love me to stand up here and tell you exactly what amount you have to provide as a gratuitous payment, but as with many things in law, it's that frustrating area of it's just going to depend. And so there is no black line of if you provide X amount of dollars, that's going to satisfy as the gratuitous payment for a release. We would look at the factors surrounding this employee, so how long have they been with the company, their salary, their role, their position, and that. Another key issue when you're considering the release and navigating that with as an employee, you need to ensure that you give them adequate time to sign and return that release. Because again, you don't want to be put in the position where an employee might come back and say, I was coerced into signing this, I was rushed into signing this, I had no idea the rights I was giving up when I signed this. And so typically what happens in a termination meeting is you're going to hand them the termination letter and the release letter, and you're going to request that they take those home and they read them so that they fully comprehend what they're signing, and then ideally getting it back a separate day, a day later, a few days later, after they've had time to really review it. So termination versus release, this can be an area of confusion when we're navigating these for the first few times, because sometimes these areas kind of get conflated together when really they're quite separate, distinct ideas. And so simply put, a termination is the end of an agreement, whereas the release is the beginning of a new agreement. So a termination, when you're navigating a termination, as you know, that's kind of a one-sided situation where an employer has decided to terminate an employment agreement, and despite their best wishes to otherwise, employees don't typically have a choice in the matter. Their employment termination, their employment agreement has been terminated. With a release, that is where an employee and an employer are entering into a whole new agreement. And so it actually is an area for negotiation, and employees are not obligated to sign these releases. However, hopefully with the right amount of consideration, they are encouraged to sign them. So a release itself is a legal document that's going to record the employee's agreement to relinquish their right to any future claim against that employer with respect to their employment. And like I said, an employee is not able to disagree with a termination, of course. However, they can decide not to sign a release because they're not obligated to do so. And the meat and potatoes, how does a release actually operate? Unfortunately, this is not a magical document that bars an employee from bringing any claim. So despite having a rock-solid release in hand, an employee still has the right to file a human rights complaint or file a claim for a wrongful dismissal. Where the release comes in is that it provides a very valuable way to dispense of these claims brought by the employee early by setting out that the employee has agreed to release and discharge the employer's liability with respect to any of these claims. So again, although it doesn't bar the employee from commencing these claims, where it comes in to save you with your employer liabilities is that it provides a much more efficient, cost-effective way of dispensing of these claims early. So they are a very valuable tool to have. So in addition to that key provision where the employee is releasing and discharging employer liabilities, release documents might contain any number of other provisions within them. And again, it's going to depend on the relationship, the employment relationship, which provisions are provided or not. Some examples include non-disparagement provisions, and this is where the employee is agreeing that they won't make any negative or disparaging comments about the employer, whether verbally or electronically. You might have provisions such as confidentiality clauses or restrictive covenants, similar to the provisions that you would find in an employment agreement. Typically, we see provisions that set out that this release is not the admission of any liability on any party's part. And like I said, the terms of these releases are really going to vary situation to situation, so it's not a standard form document that you're going to use. And also, like I mentioned, in giving that employee time to review these provisions, they might, either of their own volition or seek out legal advice, they might come back with negotiations for certain provisions within that release. And so that is something to keep in mind, that employees might come back and want to negotiate whether it's the gratuitous payment itself, maybe some of the restrictive covenants you have in there. And so we do see a bit of negotiation with this type of document. So just to sum up, just a few reminders about terminations. So as I'm sure you're aware, so where you are terminating for cause, you aren't required to pay notice or pay in lieu of notice. You also aren't required where the employee has only been employed for less than 3 months. The second point, I will admit, it's not accurate. I've put you cannot terminate an employee who is on leave. Technically, employers can terminate employees who are on leave. There's nothing stopping you from doing that. We always strongly advise against it, because typically what can happen is terminations that happen in these circumstances where an employee is on, say, maternity, paternity leave, short-term or long-term disability, is that there's a greater risk for an employee to make a human rights complaint or a claim for wrongful dismissal. And if the employee does take that type of legal action after being terminated while on leave, it is the employer's onus to establish that the termination itself was nothing to do with that leave. And even if just one part of that employer's decision to proceed with that termination was based on the leave, then that would be sufficient to establish prima facie discrimination under human rights legislation. So just warn that although, yes, you have the right to terminate someone who is on leave, you would definitely want to seek out legal advice, consider all the circumstances, and just be well aware of the increased liability risk when doing so. And finally, final wages, which would include things like their typical wages, any overtime, statutory holiday pay, those have to be paid within 48 hours of the date of termination. So of course, you just want to have your accounts on board for any terminations that are coming up to ensure that that can happen in a timely manner. And with that, I will hand it back to Andrea, or just, yep, perfect.
Thank you, Debbie. That was very helpful, informative. And so we do have 20 minutes left, and we hope to use that for a question and answer session. Again, you can sit at your table if you like, but if you're soft-spoken, you're more than welcome to come up to the microphone. We are recording this, so I will try to repeat the question just to make sure that it picks up on the recording. Hi.
I don't know, is this turned on? Yeah. So my question is about the immigration. What do you recommend when you've had an international student working for you and you want them to continue after their studies have ended?
Do you want to get it?
Oh, sure. Okay, thank you. So most of the time, again, I use the words most of the time because always exceptions. So international students, I assume they're in their graduate, undergraduate level of study. So most of the time, they can apply for postgraduate work permit, which can be up to 3 years. So given the current prolonged processing time, we recommend to submit in the application as soon as they can, which is when they finish their last exam. They're supposed to have a letter from the school. So the earlier they submit in, the quicker they can get a formal the work permit. I do also think there was also a public policies allowing they start working for the employer once while their application is still in progress.
Can I just add to that?
Oh, sure.
So, just add to that. So, yeah, postgraduate work permit is the best way, provided they're eligible for a postgraduate work permit, and that will be based upon the institutes they studied at and the course that they studied. And it's their responsibility to understand that. As long as they've made an application for that postgraduate work permit within the time frame from finishing their studies, and whilst they still have a valid study permit, then they can start work for you. So they would be able to start work straight away.
And just for the record, the question was, what do you do if you have an international student who is graduating and you want to keep on that international student working? Next question. So technically the answer to that question is yes. Even though they have requested to work from home, you are allowing it to happen and they are doing business for you. What most employers are doing these days are giving employees a technology allowance. On an annual basis, the employee can save it up and buy a new computer, or they can use upgrades. That's typically the way employers are handling it. I have to say some employers are not handling it at all. They're just assuming that the employee has their own computer set up at home, and most do. But do know if that one employee does approach you, you will, it is best to reimburse them or provide them with that to avoid a group complaint to employment standards. And for the record, the question was, what if an employee has requested to work from home 2 days a week, so they're working hybrid? Do you have to pay for their home office equipment? Yes.
Hi, thank you for the presentation. That was very informative. I have questions regarding the employee working outside the country. My question is actually how long they can work from outside the country as an employee. The reason behind I'm asking this is we have 2 cases in our company. One was employee was working in Mexico during the acquisition process. I found out, Andrea, you're probably familiar with my company, so we had the acquisitions and we found out one employee was in Mexico working there for more than close to a year at that point. So I got the advice from legal that short term is okay, but long term is a risk for us. So that we came to the agreement that they need to return to Canada within a certain time. Other cases happened was one employee, of course, now they're working from home. They especially younger generations, they want to work from anywhere they want. So one decided to go outside of Canada to work in South America. So my advice was, okay, short term is okay. That was legal advice for us, so we said, but he decided to stay permanently. So that case, what do I do? Like, can we keep the employment? We want to keep the talent, but can we keep the employment? What's advice on that?
So thank you for that. The question was, is there a time frame around which employees can work outside of the country? Is a short term okay, or at some point do they have to return? And thank you for the question, because your question is bang on the questions we get every day. First of all, employers are, I didn't even know that they moved out of the country. That's the first one. Yes. So to solve that problem, what we're encouraging employers to do when they enter into new employment contracts with employees is to actually put in the contract, if you are going to allow remote work, where that remote work can happen. If you do not want the employee to move out of the jurisdiction, you should also include that in the contract. I know that doesn't help your situation now, so moving to your situation, there is no real time deadline that applies for how long an employee can work outside of the country. There may be immigration laws that might apply, but that would be unique to the specific country. But from an employment law perspective, it doesn't matter if it's short-term or if it's permanent. So what you'll really want to do with the individual who is in Mexico and the individual who wants to go to South America is get a legal opinion from a lawyer in Mexico, from a lawyer in the South American country, that goes through all the issues that you should be aware of: immigration, privacy, employment standards, hours of work. It is a bit of an investment, and it might be, but if you have talent that you want to retain, some of our clients are doing that. So they'll go to a lawyer in that jurisdiction, ask for a fulsome opinion in terms of what it means administratively and legally, and then go from there. And the best I can say to you in terms of whether it's temporary or permanent, enter into an agreement. So if you don't want it to become permanent, put that in an agreement. Remember that, yes, you want to retain legal talent, and so there is a fine balance, but don't relinquish all of your rights and control to your employees. You're still the employer, and you still know what functions best for your organization. A lot of times that is employees being in the office or being close by. So don't be afraid to turn down requests for permanent jobs. If the employee leaves because of that, they're probably going to leave at some point anyway. Yeah.
Thank you. But in turn, if you keep it, permanently, they're living outside the country, it means, we can offer the benefit. For example, benefit insurance company not going to allow that.
No.
CPP, EI, I would keep correcting them. What do we do? Those things, just we're not unsure. How that's what the reason I'm asking how long. We have the employees that goes outside country for vacation, for example, for seeing the family in India or China, wherever.
Right.
They'll come back in 1 month's time. We have no problem with that. And we also, from the privacy point, we also inform the IT, so they're aware of where they're accessing the information. So. But become the permanent. That's really issues at this point, and is that the options for us to hire them as a consultant?
Okay, so that's another good question. So hiring as a consultant means that you're hiring them as an independent contractor. And are they really an independent contractor? Probably not, because they've been your employee. So what has changed but for the fact that they're sitting in a different jurisdiction? So at some point, if they were to be terminated, as you know, with independent contractors, they don't have the same common law rights as employees. And you'll have a contract with them that won't provide the requisite notice of termination. So now they become an employee at common law. And so they can bring a claim in the Canadian courts against you, and you'll have a very hard time resisting it and now saying that they're an independent contractor. So I would stay away from that. And again, the tax issues you raise about CPP and EI, all of that, you really need to get a formal legal opinion from a lawyer in the jurisdiction. I know one of my clients did that. Somebody wanted to move to Ireland. I suggested and I gave them a referral. They got a fulsome legal opinion. They decided, yeah, we can do this. It's not that onerous. Might be different in other countries. So that's what you really have to do, and you have to decide whether or not you want to invest in that, if retaining the legal talent is worth it.
Thank you. If you don't mind, I have a couple
Sure.
of questions for John. You mentioned about the port of entry options, but if they are coming from the country that require visa to travel to Canada, so they do need a visa, apply the visa in advance, correct?
Yes, that's correct. I mean, if they're coming from a country that is visa required, then they have to make the application at the visa office for which, at the country for which they are a citizen, or for a country to which they've been legally admitted. So let's say if they're an Indian citizen and they're in, let's say, Qatar, they have the option of making the application either in the visa office for India or the visa office for Qatar. Now, both are lengthy at this point in time, but I would strongly suggest if that were the situation, that specific, do it in India, because I know that the visa office for Qatar is Abu Dhabi, which deals with refugee applications, so you could look at years rather than months in that visa office.
Okay, thank you. And a student that now they can work for up to 40 hours, are they can be any type of student, like is ESL student count?
I'm not. Yeah, we need to check what kind of study permit they have. I don't think ESF students can work part-time, but this is the public policy might change a bit, so I need to look into it.
So the public policy relates to a student with a study permit, so that's somebody that's studying for more than 6 months and they have a study permit. If somebody's in Canada as a visitor and they're studying an ESL program or something that's less than 6 months for which they don't need a study permit, they are not covered by that public policy. That public policy doesn't apply to them.
Okay, thank you so much.
You're welcome. Any other questions? Yes.
So for just the remote working arrangement agreements that you guys recommended, I'm just wondering, are there any laws that supersede the agreement itself that we cannot kind of contravene? So for example, you have the Employment Standards Act, you both agree that it's going to be the Employment Standards Act that will apply. Are there items such as WorkSafe BC, for example, that we can't really supersede or kind of override in the agreements?
Yes, exactly. So a contract is good for common law purposes. For legislation, this is why you're going to want to be very careful before you pick the jurisdiction to make sure it's the right one, because you can't contract out of provincial employment standards legislation. So for example, if you and the employee agree that the laws of Alberta are going to apply, and the employee is sitting in Saskatchewan, I can tell you that the employee can say, oh, change my mind, I want to go to the Saskatchewan Labour Standards Tribunal, and the Saskatchewan Labour Standards Tribunal will take jurisdiction. So, you know, you have to be very careful when you put the choice of laws in the contract that it is one that is going to be accepted. Workers' compensation is another one, right? If the employee is not working in the province, you may not be covered. You'll need to check on that depending on the province, but you should just rely on the fact that you really should cover them in the province that they're actually sitting in. And for the record, the question was, if you put a choice of laws in the contract, are there any laws that will override what the parties' choices are? Any other question? Yes.
Hi. So if we have employment agreements in place prior to working remotely, and during the pandemic, people worked from home, and now they're going to continue to work remotely, and you were suggesting that we have specific wording to address that, do we have to offer some sort of consideration in terms of amending that agreement or adding to the agreement? What's the best way to approach that?
So that's a really good question. For the most part, you won't need additional compensation for that. It's a term of the employment agreement that is mutually beneficial. Unless, of course, you are forcing the employee to work remotely, then you're probably going to want to have some additional compensation. For the most part, what we're seeing is that it's really the employee who's wanting it and the employer's okay with it. So you won't need additional consideration for that, but what you will want to do is have an addendum to the employment agreement. So you're going to want to have something formal. And if there's anything in the employment agreement that now needs to be changed, so for example, you have hours of work in your employment agreement, they've been set out specifically, and that's now going to change because the employee doesn't have a commute or something of that nature, you'll want to specifically say that the new term and the remote work agreement supersedes and replaces the old agreement. Otherwise, you'll want to say in the secondment agreement, I was just working on a secondment agreement. You'll want to say in the remote work agreement that all other terms and conditions set out in the earlier employment agreement will continue to apply. So, yeah, so that's a really good question. The question was, can you just do it by way of policy rather than by contract, a remote work arrangement? The answer to that, there are certain things that should be by way of policy, such as this is the way you should track your hours of work while you're home. But the actual arrangement is a material term of their employment, so you really should have that separate contract, and then policies can deal with the nitty-gritty, the logistics. We have just time for one more question. Yes. Yeah. So if you say, "Oh, I don't want to know," that means you know, and so you'll be in trouble that way. It really is better for you to know. You really do, because you don't want to make mistakes that will fall on the company and we all know CRA is not very friendly, and a lot of the government agencies aren't very friendly and aren't going to say, "Oh, poor you, your employee didn't tell you." Again, you're the employer and you're the one that's required to monitor and control your workplace. So, yeah. And for the record, the question was, if we don't know an employee is out of the jurisdiction, should we just turn a blind eye to it? So the answer is probably not. So with that, we're at our time. We know that there has been a lot of information given to you today. The PowerPoints are quite dense, but the information is there if you need them. Every year, the font gets smaller and smaller for me on these PowerPoints, so we will send them to you electronically after this session. You can blow them up, zoom in as needed. One final housekeeping matter. Today's topics were picked based on what the feedback was from our last session, what you want to hear about. So we do encourage you to fill out the blue forms and leave them on your table, or you can pass them to Laura, who's at the back of the room. We're particularly interested on topics that you want to hear, and we're happy to address them at our next session, which will be the spring of 2023. Thank you, everyone, for joining. We'll be sitting here for a little while. Feel free to come up and ask any additional questions.